Good evening. I'd like to call to order the regular town council meeting for Tuesday, February 28th, 2023. Please rise for a moment of silence. We'll have the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Madam Clerk, would you please call the roll?
Allenson?
Here.
Carmody? Fishbein?
Here.
Laffin?
Here.
Marone?
Here.
Tata? Here. Testa?
Here.
Zandri?
Here.
Chairman Cervoni.
Here. Thank you. Before we continue, I just want to let those in attendance know that item 7, the ARPA item, has been removed or withdrawn tonight, and it may be considered at a future meeting. Can I get a motion on the consent agenda, please?
Mr. Chairman, I move we approve or accept consent agenda items A through G.
Second. Moved and seconded. All those in favor signify by saying aye.
Aye.
Any opposed? Hearing none, the consent agenda passes. On to item 5, the public question and answer period. Mr. Gross.
Good evening. Bob Gross, Long Hill Road. Through the chair to the mayor.
Go ahead.
Thank you. Last meeting, there was some questioning on the cost and the insurance money, et cetera, on the playground. And you said you were going to have those numbers. Do you?
I believe Tim Senna, our controller, said he was going to inform the council. Did he send something out to you? You receive anything?
I don't think we've received it yet.
Okay. And he's not here tonight. He is unavoidably detained elsewhere. But I can tell you there is no money coming from town accounts, which would be a deductible. The letter reflected one viewpoint. The transfer form that indicated source of funds, the appropriation or transfer, I forget which it was, indicated all of the sources of the funds, payment of the restoration of the slide at Doolittle. So there's no money coming from a deductible.
So you're saying that the deductible is being paid for out of Choate's money or the insurance money?
Right. Insurance, anything that wouldn't be provided by insurance, then the Choate contribution covers it.
And the Choate contribution, then the rest of that money is going where then? But I guess it's better wait. You send it to the council, let them see the numbers, and then you go with it from there. Because they made a specific donation for the playground, so I would hope that it would go for.
No, I believe it reflected $20,000 from Choate as part of the appropriation to handle the replacement of the slide.
You'll get it to the council. I'm not,
Okay.
I'm not doing that. On the last council meeting, you had, and this one's just because there were quite a few of them, you had quite a few tax appeals. Does this affect the grand list at all these during the course of a year? Because I'm sure they're not going up, they're going down. Does this affect the grand list?
These would be corrections to the grand list October 1st, 2022.
And can we find out what those numbers are? Are they already agreed upon? Or is it a substantial number? Is it $5,000 or is it $100,000? Is it a big difference or is it just a small number?
The practical effect financially certainly can be reported on. At this point, that was a settlement with the law department. We'd have to confirm that that has been completed. And subsequent to that, we would be able to reveal what the practical effect is, the net effect.
Because, I mean, I'm not saying just these, because during the course of a year, you have others that come, there was just 6 of them on last meeting. That was more than usual. Sometimes it's just a couple. So I was just wondering what the net effect was in the course of a year.
Well, typically, they will all relate to the previous October 1st grand list.
But it's
These are appeals from that grand list designation of taxable property.
But it's future tax, it's tax dollars that come into the town eventually.
Well, there's a settlement of an issue. They claim they were paying too much. We would claim that they weren't, and the parties look at the various appraisals and determine whether it can be settled or it goes to a judge.
I understand, I mean, and they have every
Right.
right to do, I'm not saying that. I was just wondering if it affects the grand list at all. Does
It will affect the grand list of
substantial
the
way.
October 1st, 2022, which is the grand list used for the July 23 payment as well as the January 24 payment.
So it will affect your budget that you're working on now?
Yes.
Okay, thank you. Oh, have you, on those 2 others, since I don't think there's anybody else, well, I'll concede if you want to see if there's somebody else.
Does anybody else have food for this public question and answer period? Mr. Gross, the floor remains yours.
Last, the bottle, the nips, the little bottles, and drug companies like Cardinal Health and Johnson & Johnson, have you moved forward with any of that money or thought about it?
We are reviewing the amount, and I'll be speaking with the Health Department as well as Youth and Social Services, any other departments that would be affected by the limited areas of concern that we can spend the money on.
Well, I know it's limited, but it's just been sitting there for a year or close to it, so that's why I was just wondering why it hasn't been spent. Some of it's for drug interaction and with, for the money especially from Johnson & Johnson because it's part of the opioid settlements. So it was just, these last few years have been really tough on that type of thing. Numbers have gone up. Instead of the money sitting there, it would be great to have it go into the system to be able to try and help people in town. That's all. Thank you.
All right, seeing no other takers, I close the public question and answer period and on to item 6, which is discussion and possible action regarding successor contract with IAFF Local 1326 for a 3-year term from July 1, 22 to June 30th, 25. Good evening, gentlemen. If you could please remind us who you are for the record.
Good evening, Joe Setnar, Fire Chief.
Jim Hutt, Town HR Director.
Dennis Ciccarello, Town Labor Attorney.
Thank you. For the benefit of those not here, if you could give us a summary of what the changes are to this contract, the resolution.
Sure. Good evening, councilors. We're here tonight to seek the approval of the council for a 3-year contract with Local 1326 of the Firefighter Union from July 1, 2022 to June 30th, 2025. Some of the substantive issues, I've already provided you with a summary, but some of the substantive issues are, it's a 3-year contract, as I've indicated. Wages for July 1, 2022 with 2.5%, July 1, 23, 2.25%, and July 1, 24, 2.25%. It includes an amended 3-step pay plan for emergency medical technicians effective July 1, 2022, and a wage adjustment for battalion chiefs effective upon ratification. Increases on-call pay for employees in the Fire Prevention Division to $75 effective upon ratification and $80 effective July 1, 24. Incorporates a wage rate of $1863.03 weekly, effective upon ratification for fire marshal, and provides some other benefits within the contract for the fire marshal, who's now a member of the bargaining unit. The position is increases uniforms, $100 for each employee. It adds a 40-hour work to the emergency medical technician work schedule. EMS bonuses of $100 for each year. On November 1, 22, November 1, 23, and November 1, 24. incorporates employees effective July 1, 23, will move to the Health and Wellness Trust of the International Association of Firefighters for health insurance. And that is a quick summary of everything about the substantive issues.
Okay, thank you. So before it gets to us, it goes to the bargaining unit, and they have to vote to support this. Is that correct?
That's correct, and they did vote. I believe it was 55 or 56 to 1.
Thank you. And I think this was in negotiations for a long time, headed towards arbitration. Do you think that this is a fair resolution of the disputes that have kept this lingering for so long?
Yes, I do. I think it's a fair contract for the union as well as for the town.
Thank you. Questions from the council? Councilor Fishbein.
Thank you, Mr. Chairman. Good evening.
Good evening.
I'm in support of the contract. I just want to start with that. And I see many of our firefighters here tonight, and I just want to thank you for your service. You know, there's an aspect of this document that I just want to highlight. When this contract, any contract really, is negotiated, there's two sides at the table. There's management, and there's the union that represents collectively the firefighters. But from my perspective, there's no one who represents the individual firefighter. And I want to just talk about Article 5 of the contract that's before us. First of all, I want to point out that in section parent B, I think there should be a correction. I don't know why in the future we couldn't have a female fire chief, but it expressly talks about in the last line, the chief is a he. So I think we should be more open. But starting with section 1, if an individual firefighter has a problem with their employment and they want to, and grievance is the procedure, the way I read it as we get into section parent A is the individual firefighter doesn't have the right to file a grievance. It's only the union that can file a grievance on behalf of that individual firefighter. Am I reading that incorrectly?
That's what it says in writing.
Yes. Okay, I'm looking at the document, you're looking at the document. As we get into section B, if the union decides to file that grievance on behalf of that employee, the resolution is not what the individual firefighter thinks is satisfactory. It's what the union thinks is satisfactory. Once again, the individual firefighter is not part of the process. And I understand that there are expenses on both sides of the grievance process. Management has expenses and the union has expenses. But at the end of the day, I think philosophically, as we try and support individual rights and we try and support individual firefighters, and I'm totally in support of people gathering together and associating for the purposes of collective bargaining. But I think we have to look at the individual firefighters. As we get into C, once again, if the grievance is not resolved to the satisfaction of the union, not the employee, there's a proceeding and the union may then go to arbitration. Once again, it's not the individual firefighter. It is the union that decides that on behalf of. And that arbitration is binding. There is no court of review. Many times in administrative proceedings, mediations, you're allowed to go to a neutral. You file an appeal in the Superior Court if you think there was some decision that was not right. A contract, a provision like this, that in my opinion turns the back on the individual firefighter, opens it up to collusion between management and the union. I cast no aspersions, but I'm just looking at the language because I care about each and every individual firefighter. And with that, I have to ask about a particular portion of C. Understanding that you have no right to go to court on your grievance, your arbitration. 2 lines, essentially it's 3 lines from the bottom. I'm going to read the clause. It's after the however. The full legal rights of the parties in the courts shall not be restricted in any way, and that said board shall not modify, alter, add, or subtract from the provisions of the agreement. Now, I understand the board that they're talking about is the mediation board. It doesn't go to the Board of Mediation, state mediation. It goes to the AAA of a certain time period. Neither of those bodies can alter. But what are they talking about? The full legal rights of the parties in the courts. Please. What does that mean? Because there is no right to do anything in court here.
If I may, my belief about that language is that if the town thought that a certain grievance was not arbitrable, it might be able to request a court to issue a ruling on arbitrability. And the court would literally decide in lieu of submitting the grievance to an arbitrator and having the arbitrator decide his own authority.
And what language in the contract do you rely on? I understand what you're saying, right? But that's nowhere in here, right?
Doesn't have to be in here.
Okay.
All this says is that nothing in this document restricts that right of management to go to court to seek a ruling on arbitrability.
And what kind of a proceeding would that be? Injunctive relief?
I mean, you might think of it that way. I don't know that it would be a motion for an injunction. It would literally seek the court's ruling on arbitrability, whether the parties literally had agreed by this agreement to submit that given issue to an arbitrator for ultimate decision.
Well, can you give me an example of a understanding that this emanates from a grievance? So it's got to be something in the context of the work conditions, wages, or something like that. It's a grievance to begin with, and it's already gone through step 1, step 2. So that's where this provision appears. So you're saying before it even gets to step 1 that there would be injunctive relief or sought?
No. Typically, it would only be upon the union's submission to arbitration in the first place. In other words, only when the union seeks to have an arbitrator decide whatever that underlying substantive issue is, would it be ripe, so to speak, for a court to perhaps to intervene and declare that underlying issue not arbitrable.
So that procedurally doesn't make sense to me, because you are therefore saying, before, assuming that right to go to court exists, you can't exercise that until you have already exhausted the grievance steps. So if the arbitration, well, you're saying no.
No, because the steps usually culminate in arbitration. That's the final step typically, whether it's step 2, 3, 4, whatever the step is. The steps before that don't seek arbitration, meaning a declaration of the party's rights by an arbitrator that is final. Until then, it's simply a matter between the parties. When the third party is sought to be brought in, that's where the matter becomes, I used the word before, ripe for the court, perhaps upon application by the employer, to consider and rule on arbitrability.
So then, under the confines of the document, all disputes, whether ultimately arbitratable or not, are required to go through the pre-arbitration steps.
Yes, I mean, usually there's a,
Yeah, because I'm pointing out that this language appears solely in the arbitration paragraph.
Right.
And that's why I'm saying it seemed to be a waste of time to go through that process, expedience for the employee, or perhaps for the employer. So, well, I enjoy the exchange, and I thank you. And as I said, I'm in support of the contract. I'm just looking out for individual rights here. So, thank you, Mr. Chairman.
Thank you. Counselor Testa.
Yeah, I should just remain silent, but I can't. I too care for each individual firefighter individually. I've always, maybe I'm wrong, but in most of the language here and in the whole concept of this bargaining unit, I grew up in a union family, and I remember how my father used to teach me the importance of his union and what it meant. And many times when I see the word union, I'm seeing member. One for all for one. I mean, and I think to imply that an individual member of a bargaining unit doesn't have certain rights because the language in the contract uses the term union, because that's the explanation, the declaration of how things are done. I just think that's a little, I'm uneasy with that being left up there in the air. Am I correct when it says the union shall, union may? That is the member, and the people, and perhaps the unit is carrying it out on behalf of that person. But to imply that the contract in any way restricts an individual member of that unit from having any kind of rights, and then to carry on with the discussion that we just had, that's more an expression of a philosophical problem with unions. Yeah, it is. Yeah, it is. And if we want to, and the paragraphs we're talking about, there are no changes in these paragraphs. This language has been here for a very long time. The only change in the paragraph about the grievances and the full legal rights of the parties and all was the number of days. But that language has been there, and I would assume for a very long time. So if we wanted to question all of the language in these contracts, tonight's not the night to do that. This is not, I don't know, maybe it is, but that doesn't seem to be what we're here for. But when I correct and when I see the word union, as far as in procedures, that is the member. Union, am I correct? And if I'm not, correct me. Somebody correct me, other than him. The members of the union can correct me if I'm wrong. I mean, that's how I always see this. The strength of the union is why we negotiate with the unit, and each member of the unit now has the rights that are in this contract, and so forth. But I'll listen.
Mr. Chairman,
There.
just Dennis, the foundation of all this isn't it MIRA, Municipal Employee Relations Act?
yes.
And it describes representation for employees through a described process. You can color it whether it's administrative process or whatever. It's a process, and the union represents its members through these procedures, correct?
That's correct.
And that's all set up by state law under MIRA.
Yes.
I mean, that's basically the format here. So, you know, we're not, if you're a member of the union represents your interests, and the town is obligated to follow that. It's state law, and the employees are members of the union represents them, and that's the way these matters are dealt with. So nothing, there's no, I don't know how else to color it. If there's dissatisfaction with it, it's the way state law has set it up, and generally it works to the benefit, hopefully, of everyone.
So an individual has the right to opt out of membership in the union. Is that correct?
Yes, an individual cannot, to my knowledge, opt out of membership or being counted within a bargaining
Right.
unit.
That's
But membership in a union, you're correct.
yeah. So you can ask not to have the dues taken from your paycheck, and while you're a member of the bargaining unit, you are not a member of the union. Am I correct?
If you're still a member of the unit, whether you're
Okay.
a member of the union or not.
Right. You're a member of the bargaining unit,
Yes.
but you choose not to pay the dues and affiliate, if you will,
Right.
with the organization that represents the bargaining unit. Do we know how many members in this unit have opted out of paying dues?
I would have to defer to the union, but my memory is
Okay.
none.
I think the president is eager to talk, and I'm going to recognize him and give him an opportunity. So if you could just tell us who you are for the record, please.
Shock Page, President, Wallingford Firefighters, Local 1326. So we have 0 members that choose not to belong to the bargaining unit. Janice allows them not to pay dues, but we still represent them. So the articles in the contract, we're still responsible to honor the contract and defend them if needed, even though they don't pay dues. So that's that. The union owns grievances, and that's intentional. It allows the collective, instead of putting the burden on an individual. By the union representing it, we have resources through the state association and the International Association of Firefighters. The member is involved in every step of the way. They bring the grievance to us. We, as an executive board, review it, make sure it truly is a grievance, article and section, and then we go forward. We present it to the chief. The chief makes his assessment. If it's not to the satisfaction of the individual member, then we take it to step 2. If it's not in the satisfaction of the individual member, we take it to step 3. At any point in time, the member can choose not to go through the grievance process and exercise their own rights. Nothing in this contract forbids them from doing it. It just allows that if they go through the union, then it's the union saying we've been aggrieved because it's our language, not an individual person's language. So now not one person is fighting the town. The bargaining unit is saying we have language. This member happened to be the person who experienced what we believe is a grievance. The Local 1326 has been aggrieved. Every grievance starts with Local 1326 has been aggrieved, and then we list the article section and what we believe was wrong. So the union is the member. The member is involved in every single step of the way. If we don't have the resources, we get them resources. We refer them through the IAFF, or we allow them to get their own individual representation. So although we represent everybody, we're not the exclusive that it's up to us. The member gets a say as to what happens, and the only time a member may be told no is if we don't believe as a committee that a grievance has occurred. And that, just because we don't feel it, doesn't mean they've waived their rights to seek their own counsel and pursue the item. So I hope that offers some clarity.
Thank you. Apparently the academics in the room are not done. Councilor Fishbein.
I'm just questioning, under this contract, what individual right is recognized? when I just heard that if the employee does not want to go through the grievance process for whatever reason, or that the union doesn't approve them going through the grievance process, what individual right as an alternative is recognized in this contract? I don't see any. So, I mean, I'll tell you, I know that the language, and I have no problems with our firefighter union or a group. I'm just looking at the contract that's before us. I have a case right now where I represent a school teacher. The union said, we're not filing the grievance for you, and made a problem. The individual right of the school teacher would have been a different situation. So if that individual right exists, which I just heard about, I would hope that it's in here somewhere, but it's not. So ultimately, I'm looking at the language before us, and my understanding is there's a gatekeeper to the filing of a grievance, there's a gatekeeper to the whether or not the result of that is to the satisfaction. It's not the satisfaction of the member, it's the union. And I just think that it could be problematic, as it is in the case I generally told you about. So, thank you, Mr. Chairman.
Thank you. Questions or comments from the public? Don't see any. And am I correct to understand that if we take no action tonight, that this will go into effect on March 20th?
That's my count, 44 days from the, literally it's Sunday, but I think it would be interpreted as Monday, the 20th, 44 days from the tentative agreement.
Great. Thank you.
Question?
Sure.
If, does that impact the effective dates of any of the wage increases that are included in here? In other words, if we've...
They're for the contract term.
Right. So, I mean, if is there a difference in the effect of this contract if we motioned and voted tonight, even though we typically don't? Is that delay going to have any impact on anything?
So there would be one wage adjustment for battalion chiefs, which is effective upon ratification.
But nothing gets delayed.
I just know that
He's
we're
asking if that would be delayed, and it would not be from the time when it's effective.
My read is that it would be effective on March 20th.
But the wage increases for the EMTs, for example, becomes effective when?
Those are retroactive to July 1,
All right,
2020.
so we're not delaying all that by not...
Correct.
And I know that we like to follow the normal procedure and not, and let things go the way they normally go. Otherwise, I would push for a vote right now, but if the normal procedure is in everyone's best interest and no one loses out, I'm good going as is. Thank you.
All right. If there is nothing further, then thank you for the presentation, and there's no further business on the agenda. I'll entertain a motion to adjourn.
So moved.
Second.
Moved and seconded. All those in favor signify by saying aye.
Aye.
Any opposed? I declare this meeting adjourned.